Hello friends, Mandar here. I'm back with another video. Today we will talk about some more tweets from USCIS that give some more direction on applications for 485. We'll also talk about some people getting their green cards without their priority dates becoming current. And these are more and more people who are contacting me on this. So what's happening there? We'll also talk about the cases being transferred from Texas Service Center to National Benefit Center. What does that mean and what can you expect? And then there is an interesting news on Eagle Act that came into picture. Many people don't want to talk about any new laws this year, but I will mention it anyways. So if you are interested in this topic, watch this video until the end and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration related videos for US and Canada. I'm not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. And for your specific immigration needs, before you take any action, you should hire a competent immigration lawyer. Hello friends, Mandar here. Now you will ask, what is this cricket NFTs? Now I'm collaborating with somebody who is working on this project for cricket for NFTs, and I'll have more information in my upcoming videos. So stay tuned to my channel because I'll be giving out more information on this topic in my future videos. Now the first thing I wanted to cover is there are at least 5 people who have contacted me in terms of getting they recently got their green cards. Now they have been waiting for their green card for a long time. They have been in the retrogression through EB3, but they got their green cards anyways. So is that a mistake from the USCIS, and what is going on here? So when first person contacted me on this topic, I was a little bit surprised that this is not possible, because USCIS just doesn't give out green cards before your date becomes current. But then more and more people started contacting me with the same situation, and in some cases neither their filing date is current nor their final action date is current, which is interesting because now what is the basis for them to give out these green cards, right? Now the reason I'm thinking this is happening is there is a lot of new hiring that is going on in USCIS, and in addition to that they are also getting the pressure from administration to use up all these green cards that are available for employment based category. Now in doing so, some things are falling through the cracks and officers are not realizing that they are issuing out a green card without their dates being current, which is interesting because these things are supposed to be electronic. There should be some flag coming up that you cannot assign a visa number to a person that doesn't have a current priority date, but that's happening anyways. So what can you do in that situation? Now this is very common in the marriage based situations where people do get their green cards, their permanent green cards after their conditional green cards after some times, and there are mistakes that I have heard about in the family based section, but never in the employment based section. So you have to be careful because this green card might not be the legitimate one that you will get from the USCIS. You might want to check with your lawyer, send a letter to USCIS to confirm its validity, and also get the information on how did they issue your green card. It is in your interest because in future if they revoke your green card knowing their mistake, you might get into trouble. The reason is once you get your green card, you are no longer in adjustment of status. Now if your green card is revoked based on the fact that it was given out in mistake, then you don't have any valid status. It doesn't automatically put you back into AOS if many months or years have passed. Whereas if you do it quickly after you get your green card, realizing that they have made a mistake, you might be able to get back into the AOS status, which is adjustment of status, pending adjustment of status, and that is a valid status to be in. So that is just my recommendation. If you are in a situation like that, let me know. I'm creating a database and keeping in touch with those people regarding what's happening. This is unheard of in the past, so we don't have much of a precedence to what needs to be done, but I just thought it was important to mention. Now before we move forward, I would like to remind that I have some affiliate links in the description, and if you use those links to purchase a product, the channel will get a little bit of a commission and it will really help the channel. Now let's look at this sponsor video before we move on to our next topic. And that brings me to the sponsor of this video, which is Surfshark. Surfshark is a VPN provider, and that gives you a lot of benefits that you are looking for. Now here is what all Surfshark has to offer. It gives you the power to protect your online privacy, control your personal data, access content safely, and unlock the exclusive benefits of this. What else can it do? You can browse privately, encrypt your internet activity so that no one can steal or track your data, hide your location. This is the key when I was talking about being able to watch the Netflix and Amazon from different countries. Block ads and malware, stay safe on public Wi-Fi, keep searches private, and get real search results. And if you are in the tech or IT industry, you know what VPN can provide. Now if you click the link in the description with my code Mandar, you will get a discount, almost 83% discount on VPN deal, and plus 3 months of absolutely free VPN. So check out the link in the description, and if you do get the Surfshark through my discount code, it will also benefit the channel. I also like to remind you that there are a lot of people who contact me regarding their plan to move to Canada. As you know, there are several different situations where people may find it difficult to stay in the United States and may be seeking out some alternative such as Canada. One of the classic example is if children are aging out, they can no longer be as a dependent on their H1 parent, or neither they can be a dependent on their green card application if they age out, which means if they turn 21. So their options are either to get on to another kind of a non-immigrant visa such as F1 visa, but if that option is not possible, then they look out for moving to Canada. You can remember, you can do your exact same job that you are doing in the United States in Canada. Now I have some ties with a Canadian immigration lawyer and a company who actually helps people in this situation at no cost to them. So I will be doing a live event on May 5th at 4 p.m. Eastern time with the Canadian immigration lawyer and with a company CEO who does this for living. So they help people who are in such situation, crunch situation, to move from United States to Canada, either doing the same job from Canada or actually finding a new job in Canada. So if you are interested in this topic, mark the calendar for May 5th at 4 p.m. Eastern time. I will be doing a live event on this. Now there is a recent tweet again from USCIS. Now this has to do with people expecting that if they send their application to a particular visa center, their application might be picked up sooner and processed sooner. So USCIS is actually clarifying it. And now I think they don't want to admit that some processing centers are faster than others. So what they're saying is you don't make another application to another visa center or processing center. So say for instance your application is in Texas Service Center and it was stuck for a long time. Don't go ahead and make another application for 485 in another service center and submit, because that is not going to help. That's what USCIS is coming out and saying. Now in my previous videos I had said multiple 485s are possible, but in different categories. So if you have one in EB3 and you also want to file one in EB2, that's quite possible, and it's perfectly fine to have two parallel applications going on. But if you are planning to file it in the same category and in a different service center, that is probably not a good idea, and that's what USCIS is saying here. Now talking about the service centers, there is another thing that is happening right now, which is all the pending cases from the Texas Service Center are being transferred to National Benefits Center. Now a lot of people come back to me and say, okay, now that I have got a notice in the mail that my case is being transferred from one service center to another service center. It is probably from your primary service center, which was Texas or Nebraska or California, to National Benefits Center or to a field office. So look carefully at your notice and it will tell you the address where it's being transferred to. Most likely it is National Benefits Center, but they may also be sending it to the field offices or district offices as they call it. Now you may ask whether it's a good news or a bad news. In my opinion, it is a very good news. The thing is, instead of having it sit and going nowhere in Texas Service Center, now at least your application is moved to another service center where somebody will actually look at it. Now if your case was already looked at Texas Service Center, if it was already validated by by a visa officer, then that case will not move to another center. But if it was not touched at all, if it was just sitting there, then they are moving those cases to National Benefit Center in smaller chunks at I think thousands per week or something like that. But regardless, this is a good news, because now new fresh set of eyes are going to look at your case. It is going to be pulled out from the stack of the cases, and now it's going to be looked at. So how fast this processing is going to be, it's not really seen yet. The reason is National Benefit Center don't really adjudicate all these employment based 485. So this will be additional case load on that particular center. So we are not sure how this is going to impact, whether it's positive or negative, but the fact that this is being moved out from this ever backlogged Texas Service Center where the case is not moving anywhere, at least now it has a chance to get into the hands of a visa officer and be adjudicated. So that's the way I look at it. So in all, I think it's a good news because there is some movement, if not all at all, on your case, and it's likely that your case will be adjudicated in the near future. Now another question, and this is very common, because somebody comes to the United States, they work for a few years, they have applied for their 140 I-140, and it is approved, and then nothing happens after that. So basically they after a long wait, since their date is not current, they probably have gone back to India. So after working in India for a very long time, after that having their I-140 approved, all of a sudden now their date becomes current. Now being in India, they cannot apply for adjustment of status. So 485 adjustment of status is only available if you are physically present in the United States. So it is adjustment of status, so you are changing your status from non-immigrant to immigrant. Whereas if you are in India or outside of the United States, you have to go through consular processing. So what will happen is, once the National Visa Center, now in this case, they know that your date is current, they may contact you. So if you haven't already updated your address at USCIS, do change your address immediately, and make sure that your USCIS always has your current address, even if it is an international address, so that the National Visa Center can contact you to proceed your case a little bit further. So what happens is, the National Visa Center, once they see an application is now current, they as long as they know your current address, if it was in the United States, they would have forwarded it to the district office closer to you. But now that they see that your address is in India, so they would send your file to Indian consulate, the US consulate in India. So now and they will send you a notification letter as well. Now it's your duty to take that notification letter and make an appointment with the consulate in your country, and do the further processing of your green card. Now remember, you don't have a valid US job offer at this point of time, because you have been working in India for a while. You need a valid bona fide job offer to complete your green card process, EB green card process, because remember, your application was based on an employment based petition I-140 based on a job description. Now you need to get another job or similar job, or see if your the original company that filed for your green card is willing to hire you back. If that is the case, then get another letter from the company of a valid job offer, and then use that to complete your consular processing of your green card. So that's what I would suggest in case you are in India and your date becomes current and you want to process your green card. So this is the way to do it. Now here we go again. Remember that EGAL Act we talked about several months back, at least 7 to 8 months back, that had to do with removing the per country cap from EB category. So now it looks like that has again peaked back again. Panel, the house in the Congress, they have a separate panel for these immigration related things. So they have just brought this back up for consideration, and they have passed it. This doesn't mean that it has passed in the House at all. It will have to go through the broader House passing and then Senate passing as well. So it has long ways to go, and given that we are in an election year, I don't foresee any changes in immigration, at least for now. unless there is an executive order that gives some provision that takes care of some provisions of the immigration. But other than that, I don't see this happening this year. But the fact that they are pulling it out is suggests that it still has some attention. People are contacting their senators and congressmen, and it is pushing these congressmen to bring this bill back up. Whether or not it gets passed this year or next year remains to be seen, but this will have a significant impact on the movement of the processing of the EB green cards. The reason is, if they remove the per country cap, the backlog situation will recede a little bit. In my opinion, the reason there is a backlog is because the funnel is not in the right shape. It has a wider mouth at the top and narrow at the bottom where the green cards are flowing. So incoming I-140s are in the vast majority of the number, and that number is significantly higher than the per country limit that they have, and also the per year visa caps that we have for EB category, which is 140,000 visa numbers. So as long as there is a gap between what is coming in and what is getting approved on the other end, we are always going to have this backlog situation. But this particular bill considers eliminating per country cap, which might alleviate some of that backlog, so which should be a good news. So that's really what I wanted to say in this video. If you like the content of this video, do hit the like button and consider subscribing to my channel. Again, as a reminder, I will be doing a YouTube live event on May 5th on Canadian immigration, and this might be helpful for a lot of people who are on OPT, who are on third year OPT and not able to get their H1B processed, and also those people who are in the long wait for their green card and considering moving to Canada to do their current job. So if you're interested in that, do make sure that you attend my live event on May 5th at 4 p.m. Eastern time, and I'll see you in the next one.